Good morning, good evening. I don't think good afternoon to anyone so far, but uh, yes, this is part of our ILA discussion. We in our meeting in Ahmedabad in November. This was decided that we should have, as far as possible, a meeting, if not every month, at least bi-monthly, and take up a topic of you know importance. And I think that is something that we will do very, very shortly. Um, I uh, I think there is one. I mean, the law is always is sort of ever changing, and sort of sometimes they happen on a daily basis. Like the Supreme Court sees cases of all types, I think, but things which affect us are. So I had a very interesting chat with a few of you, and I think uh, Suhas, you're on. Would you like to say what you uh, would like to, you know, do on this particular topic that we discussed?
Sure, thanks. Thanks, Jamshed. Am I audible?
Yes.
Yes.
Yeah. So thank you, Jamshed. Good evening, everybody. Good morning, good afternoon, all parts of the world. Uh, See, what I thought was, very quickly we look at the Bar Council of India's, rules that have been framed and notified today, in understanding what does this mean and how does this impact. You see, impact from the point of view of foreign lawyers coming into India, whether it is fly in, fly out kind of a stuff that they're talking about, or whether it is setting up of the offices. How does this impact the profession in India, and how do we look at what's going to happen in future around this space? Because I think it's important for all of us as professionals to, whether we like it or not, you see, it's happening. Whether it is good, bad, or ugly, we have to live with it. And from that perspective, I thought maybe we should deliberate, we should have some kind of webinar, kind of connect with everybody, amongst all ILA members at least, to say that how do we foresee this and what do we do as a professionals to look at this as a challenge in future, or how do you factor this in? Because whether it is game changer or not, it's going to stay there. From that perspective, I thought maybe, as soon as about a week or 10 days from today, we can hold this meeting, we can hold this conference and actually start deliberating. It could be in the form of panel discussion with Q&A, it could be in any form that we want to consider.
Sure. So you would, I mean, would you like it, of course, it to be an ILA? So then the most preferred one is always, through video conference, because, or a Zoom call, so that everybody, around the world can join. And we would really like, I mean, and we'll put that out. We definitely like, our colleagues who are outside of India to, to give their perspective to this, because I think that's also extremely important. In so fine. We can quickly decide, which day of the week, or, maybe next Wednesday, Thursday, whenever it is convenient. Uh, Second. Jenna, are there any particular days that are suitable to you?
I was just going to say, should we put up a poll? Because I think Wednesday seems like in the middle of the week and easy to do. So if we can do next Wednesday or the Wednesday after that, or even Tuesday earlier than that.
Okay. I think Tuesday and Wednesday happen to be two festivals of different communities.
Oh, is it? Sorry.
I don't know. That's what India is great for. I don't know. No, but you can.
I mean, I was thinking earlier rather than later, to be honest.
I agree. I mean, I don't even mind Monday. I mean, if but let's see. Suhas, how is it for you? We can.
I think Thursday would be better. See, Monday would be too soon.
Sure.
because you're hardly getting 3 working days to connect with people.
Okay. All right.
I would say 23rd would be better. See, 22nd is Padwa. Nobody would want to, and it's all across India. I
Yes.
think that's for sure. I mean,
Sure.
so I would say 23rd we should target, which is next Thursday.
Just one suggestion, Jamshed, that since we are looking out to outside ILA members, so Monday would be difficult for them because it would be starting of the week, and it would be morning for many of the outside ILA members. So I think if it's in middle of the week, as Suhas suggested, that would be better, or maybe Friday, some sort of Friday afternoon or something. Monday would be too early. That would be difficult for many of the outside members.
No, fair enough. So maybe, I mean, Thursday is a good option. Let's see. Let's try.
Should we put up a poll of like 2 days and people can just choose?
Yeah.
I think
So
that's
Thursday evening and Friday evening, I guess. Like IST Friday evening, I suppose. Same time.
Yeah.
Good morning, Jamshed. This is Paru from Phoenix.
Yeah, hi.
I'm doing great. A small request. I saw the post on the LinkedIn you made, and then also in our group about the BCI allowing internet opening up its doors. Does that link contain all the information before I join the discussion, or is there any more information and material for us to look up and review before we talk about it?
Well, if you go through the posts on the ILA chat, I think that is, covers most of it. The important one is actually the notification, which is, I think, half of it is in Hindi, and then the English part is the other half. So you can go through that as well. Sure.
Okay, appreciate that. Thank you.
I think there is a PDF of the rules below that post. You can read that PDF.
Okay. So I think let's get on with our the topic for discussion for today. We are really pleased to have, although I can't see him, Dr. Nikhil Datar. Has he blanked out or what?
Yeah.
Yeah,
there you
a couple of minutes ago.
No. I think. Yes. Okay, so great. So I think I'm probably the most suited person to introduce Nikhil. He's more of a friend now, and we had it was in quite interesting circumstances that we actually met. There was a petition that actually he had filed in the Bombay High Court, and on that particular day, the counsel who was supposed to actually argue the matter, he was not available, and I was drafted in, and thereafter started this absolutely amazing story. The petition was which is now called the famous Nikita Mehta case. This is in 2008, where the question of whether abortion could take place, given the fact that the Indian Act did not allow abortion beyond a particular number of weeks, and Dr. Datar and they had filed this petition, and I mean it was clearly, I mean, landmark in the sense we were in court every single, I mean, I think every day, or perhaps except one day, for the whole week. Anyway, and of course, the result of that was that they said that this forms, this needs to be looked at more, more from the legislative perspective, and I think thereafter it went to the Supreme Court. But interestingly, many years later, the government has sort of now accepted pretty much what we said in 2008. So that's how I met Nikhil, and I think his the good thing about great people is they persevere till the end, and I think that's one of the finest qualities that even Nikhil has. So I think that's great. We also have Dr. Sunil Khatri, who is also a medical legal expert. He is, I mean, he's done fantastic work both in the field of medicine and thereafter now as a lawyer. Some of his uh, cases that we read about, on medical negligence, etc. I mean, kudos. And we are very happy to have these two stalwarts with us. Of course, today's topic is the famous one on the living will. So Nikhil and Dr. Khatri, please take it away.
Well, thank you, Jamshed. Thank you very much for the kind words. It's almost 14 years now altogether, and a lot of things have flown below the bridge. Ultimately, my petition, Nikhil Datar versus Union in the Supreme Court, and more than 321 cases that I filed, or I got them filed in various high courts. We were able to finally convince the judiciary, and then judiciary put the required pressure onto the union, and ultimately the union had to say in an affidavitized manner in the Supreme Court that they are looking at changing the law of the land, and that's how ultimately in 2021 the MTP Act got amended, and there is a lot of interesting developments that have happened. The pregnancy can now be terminated up to 24 weeks and even beyond in certain kinds of scenarios. Of course, it's not like ideal scenario. While drafting this law, they have made few more mistakes and problems that they have got created. So I have again freshly appealed against the amended MTP Act, although I have to accept the fact that there is a significant improvement in the MTP Act as and how it was earlier on. So basically, my brief introduction is I'm a gynecologist practicing in Mumbai, and my profession is to practice gynecology. My profession is not to hold anybody's brief as such, but I am a law graduate. I did my LLB from New Law College way back in 2002, and I have been using the knowledge of law for the purpose of health right activism and judicial activism and supporting them. So another piece of work that I did was, which probably most of you must have seen in Satyameva Jayate, where I was interviewed by Amir Khan for the work that I did around bringing in gender-sensitive protocols for examination and evidence collection for rape survivors, which has now become a national program. So these are few of the interventions that I continue to do. And the third one, of course, was the living will that we are kind of talking about at this point of time. So I just want to know, Jamshed, that, I mean, how do you want it to go? Like, you want people to ask questions, or you want me to say what I did and why I did and how I did, and what is the way forward for people to do, how they should guide their friends, colleagues, clients, etc. How do you want the format to be?
Yeah, I think the latter. If you can, just tell us more,
Okay.
and then.
So before me saying anything further, I mean, if Khatri sir wants to make any pressing comments, sir.
Thank you very much, Nikhil, and thank you very much, Jamshed. It's a pleasure to be with you all. So Nikhil has done extensive work on this, and I will really be thankful if Nikhil takes us through his journey, and we have lots to learn from him. I acknowledge this fact which Jamshed mentioned, that I am a surgeon by my training, my profession. I've spent more than 40 years in the health sector, and mid-career I'd done law, and after a full career in medicine, now I'm practicing advocate in the field of medical negligence. I primarily practice in Delhi in the consumer courts, and as well as in the High Court of Delhi and the Supreme Court. I would look forward to lots of information and taking us through from Nikhil. I would just say that what I have been able to gather is that the process has been simplified earlier than what was there earlier in the common cause judgment. And the second thing is that those who have a living will, there is a process defined, and those who don't even have a living will, also there is a defined process, so that the patient does not continue to suffer, the body doesn't continue to suffer, and also the family is able to not, I mean, the family doesn't suffer financial hardships. So the law has been definitely simplified, and thank you very much. And over to Nikhil.
Yeah, so primarily this is all, the whole thing has kind of got geared up because of this February 23 judgment. Okay, and if I may say, give you the citation, is the miscellaneous application number 1699 of 2019 in the writ petition civil 215 of 2005. So a brief background story. We all have heard of this famous case of Aruna Shanbhag, and this case is actually called as common cause versus a union, which was there in the Supreme Court. And Supreme Court basically at that point of time said that in our country, active euthanasia, okay, will not be practically allowed, but they were little lenient in terms of the passive euthanasia. That means basically withdrawal of care or withholding of care. Now, when we talk of passive euthanasia, primarily it means that if there are clear written instructions given, which is typically called as living will, whereby the person expresses beforehand, that what should be the care that should be given to him or her when that person has lost the capacity of taking decisions about himself. So now it's a settled law now that we as an individual have a right to refuse treatment. Nobody can force the same on us, and that's not really a problem, especially currently the scenario the way it is, where right of privacy has been accepted, so on and so forth. All the more reason for us to kind of refuse the treatment. But the practical difficulty is that you have a gentleman, probably somebody who is quite old, he is dementic or he is kind of terminally ill, he loses his consciousness. And the question comes up that what should be done, because there is no realistic possibility of a meaningful recovery out of that kind of a disease. Now the difficulty and catch-22 situation is that typically as hospital and as doctors, we are kind of, first of all, we are increasingly becoming a litigant society, number one. Secondly, we have our own code of professional ethics and all those kinds of things. And if at all, suppose the person says that I don't want to have the treatment, then the person can refuse to take the treatment and simply go away from the hospital by taking a discharge against medical advice. But typically here, the situation that happens is, imagine a situation of an old man or a woman where he has maybe two siblings, and one sibling feels that treatment should be continued and aggressive treatment should be continued in terms of ventilation, feeding tubes, catheters, so on and so forth. And maybe the other person feels that treatment should not be kind of continued because meaningful recovery is not possible, and it's just waste of time, money, energy, etc. And most importantly, it is kind of a very pitiful condition of the person who is undergoing that kind of a treatment. Now, typically we find, parents or the father or the mother have expressed some kind of a will to one of the children. The other child is not aware, or there is a difference of opinion between two children. There might be many external factors at the background, property, so on and so forth. And that's why it becomes very difficult, okay, for the doctor to understand that whom to listen to, because the person has lost consciousness. So now automatically, the consent has to be obtained from the relative, but out of the two, which relative? And again, there is a lot of lack of clarity on that. And ultimately, we also know the fact that there is always a potential possibility of hospitals continuing the care, from the point of view of the financial aspects of it, because this care turns out to be costly. And this care can very easily, meaninglessly prolong someone's death, given the advances of medical treatments that are possible. So how do you kind of find out a correct and appropriate solution, keeping the person at the center of the situation? Because otherwise what happens is that it's all happening about that person but actually everything else is taking precedence over that person. Hospital and doctor has their own agendas maybe, or fears maybe, whatever you want to call it as, and the relatives probably having the same type of thing. And that's exactly where this particular passive euthanasia or advanced will came into picture. But unfortunately, the conditions that were laid down were so very difficult to meet, because you have to go to JFMC and all sorts of things which were practically impossible. And I remember one of our professors from KEM Hospital, Dr. Lopa Mehta, you know, she was a professor of anatomy. Generations of doctors have been trained by her. When she tried to file her living will, it was not possible for her to file her own living will. So that's why this miscellaneous application was moved, and ultimately the apex court kind of toned down the guidelines. So now I will just simply come to the guidelines. What has changed? So basically today it is very simple. Like any other will, a person can make his own will or her own will, as far as the living will part of the story is concerned, in which he expresses as clearly as possible that what exactly he wants, what are the conditions when this particular living will come into picture, what does he want? Does he want the cardiopulmonary resuscitation? Does he want ventilation? Does he want feeding tubes? Does he want dialysis? What things exactly he wants, what things he exactly doesn't want, and in which conditions and scenarios does he want. So typically it will be impossible or incorrect to say that in any condition, if I have lost consciousness, don't do anything to me. Probably that will not be an appropriate thing to do. But something like, if I have become dementic, if I am terminally ill, if I am in the last stage of cancer, if I am beyond a certain age, so these parameters can be added to the living will, so that you are kind of giving a certain, I mean, you don't want somebody having a cerebral malaria and unconscious, to be treated and removed out of ventilator or something of that sort. So automatically we want to take the required safeguards in terms of when should this living will come into the picture. Secondly, we will have to employ one person who will be the proxy holder of the consent or of the decision making. And accordingly, one is supposed to write this kind of a document. One can also add things about organ donation and all those things that they want to add. It is very important to know that all these things have to be in a different document. They cannot be a part of the regular will, because as everybody knows, and as lawyers, who better than you all will know, that will be read only after the death of the person, but living will come into picture prior to the death of the person. So that's why you require a separate document for it. Now, what do you do with this kind of a thing? So, of course, you require two witnesses. You do not require registration. Like will also does not require registration. This also does not require a registration. And they have now added, instead of JFMC, you can just notarize it, or you can just go and get sign it in front of a gazetted office. Now, the whole idea of concept of registration, and as lawyers, we always, I'm sure you always must have advised that although will need not be registered, it's always a good idea to register. So probably what these people have done is that they have kind of, given away the need for the registration. But in order to kind of ensure or kind of put in a safeguard, in terms of kind of misleading the scenario or flouting the scenario and all that kind of thing, what they have done is that they have said that once all this formality is done, one copy of this should be sent to a custodian. So who is the custodian? It is expected that people from municipal corporation, Gram Panchayat, local government should appoint somebody to be called as a custodian. And the job of the custodian is to basically keep this document. So indirectly, we can say that it is kind of a registration in an informal manner. I mean, you don't have to go in front of the registrar, but you have to just give the copy to that particular custodian. So it will be very easy to trace that actually this document was received, blah, 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 20 years back when the person was in his full force. So the chance that somebody kind of misuses this kind of a situation against the interest of the person can be sort of taken care of. That is what probably, because I think it's a balance that they have tried to achieve by on one hand that it should not be misused, but on the other hand it should be made easy. So that is the balance that probably they have tried to strike. So the formality is over actually. I mean, it is as simple as this, that we all can understand. It has made it very, very simplified at this point of time. Of course, we are aware of the fact that there is no custodian at this juncture of time. So I am supposedly supposed to be the first person who has completed this formality of completion of the living will. And this is the copy of my living will, okay, which I have kind of notarized, and I took two doctors along with me. My only junior colleagues came with me as witness. And after that, what I did, that after I found that there is no custodian appointed, and I don't think there is any custodian appointed, what I did was that I sent a copy of this to the Municipal Commissioner of Mumbai with a covering letter saying that I can't find any custodian anywhere. So you are the head of the institute. I am sending this to you. You can appoint whosoever is the custodian. Please see to it that this particular document is stored. I suppose that more number of people should do this, because if they do it, then it will be kind of a pressure on the government to appoint these custodians, so that the process is complete and whosoever is in need of such kind of a thing or a scenario can be helped in these kinds of situations because of doing this kind of a living will. So this is the first part of the story. Now let us come to the second part of the story, that how does this whole get effected at the end of the day. So the way it has been drafted is, it's all there in the order, but I will make it simplified. At any juncture, when the gentleman has reached that kind of a stage where the relatives feel that probably that point has come where the living will needs to be kind of taken into consideration, it is expected that the relative who is already aware of the living will, because one of the copies will be with the proxy holder as well, the relative as well. So since he's aware of this fact, he is supposed to present it to the doctor who is the treating doctor and tell the doctor that, look, this gentleman has made this kind of a living will, and I feel as a proxy holder that the requirements are being met. So first and foremost, the treating doctor will kind of concur with that particular fact that the conditions are met. And if that is the case, then he will inform the authorities of the hospital. So authorities of the hospital will set up one primary board, and primary board will consist of the treating physician and two other physicians from the specialty where it is concerned. And these three gentlemen, these three doctors will come to a conclusion in terms of whether this particular thing can be effected or no. Number one. Now, if they come to a conclusion that yes, this can be effected, then they are supposed to inform the authorities of the hospital, and the hospital is supposed to then form a secondary board, which will consist of three different physicians other than these first three physicians. And out of those three physicians, one is supposed to be a representative of the chief medical officer of the state. So you can say somebody who is a government officer or a government doctor, basically. And within 48, preferably within 48 hours, that's what is the wording is, preferably within 48 hours, this secondary board is supposed to come to the hospital, examine the person, and again concur with this particular fact that, well, this can be executed. Now, if both the boards have executed, and if there is primarily the consent given from the proxy holder, then they have said in the order that after that you are supposed to inform the JFMC. Now, they have said you have to inform. I don't understand what is the meaning of inform, because does it mean only inform, or does it mean that the JFMC also has to give the permission? That is unclear as far as this judgment is concerned. But once the JFMC is informed according to the order, then the plug can be pulled and this problem can be solved. So what happens is that currently, whenever such kind of a situation happens in a informal manner, okay, the doctor and the relatives kind of decide what to do, what not to do. But doctor is always jittery about it. So usually hospitals and doctors will say, you take the gentleman against medical advice and go home. But relatives don't want to take the person home because they are really scared of managing the person at home, how to keep the person pain-free, how to give at least basic nursing care at home, and last and importantly, what to do if at all the death certificate is required. So these are typically the questions that the people the relatives will have in their mind. So now what will happen is that because this is what is the process, the person can be given a respectable kind of a palliative care in the hospital setting itself till the time the person dies peacefully. And it will be in a very respectful manner, and that pitifulness that person has to go through probably will be avoided. And as Khatri sir said, that if the person has not done a living will, even then somebody who is the best kin can come forward and initiate the same process. That is what this particular judgment talks about. So by far and the process will remain the same. But of course, I mean, if the person has made a living will and kind of put forth in a lot of clarity and in writing about what does he want and what does he not want, then I suppose the hands of the relatives as well as of the treating doctor will be much strengthened, so it will be worthwhile to have living will done so that it clarifies the things and make things much more easier. Now, there are many unanswered questions which are there in this particular judgment, because first of all, we are kind of considering that all this thing is happening in the hospital. But what if at all the hospital is not in the picture at all? Then how are we going to deal with this scenario? We are unclear about. We are unclear about this particular. Achha, one more thing which I forgot, that since we have this digital health mission going on, where we are expecting, like you have UPI, you are expected to have you are expected to have your health records also in the digital format. They have said that if there are such digital records are available, then this particular document can become a part of the digital records also. So imagine a situation that today I have made a living will and I have made my say son or daughter as my proxy, and for whatever reasons best known, the proxy does not come forward and tell the doctor, okay, look, my father has made a living will. But doctor, while browsing through the digital records, comes to know, that this particular gentleman has made his living will. Now, in such a situation, is the doctor expected to initiate the process suo moto, or he has to kind of keep mum and wait for the relatives to come forward? In this situation, is what is going to happen? We do not know about that. We do not know about the fact that what if at all the gentlemen don't, amongst the various teams, if they do not concur. I mean, of course, Supreme Court order has said that under Article 226, you can move the High Court in such a situation. I mean, they have made it that way. But honestly, moving a High Court in such a situation and all that is definitely going to be very difficult kind of a situation. So I'm sure there is a lot of improvement which can be probably done, because even something as simple as that they have said that if the living will copy is kind of provided by the proxy holder to the doctor is supposed to once again verify, from the custodian as to whether this particular thing is, true or no. Now, today, though, we don't have custodian only, but even if suppose we have a custodian, it will be so difficult, for anybody. Say, let's say I am in Delhi after 20 years and I am into that kind of a situation, and I have put my living will with the custodian over here. Okay, then how are we going to kind of, a doctor in Delhi, how is he going to get in touch with the custodian and confirm all these kinds of things? That these are all unanswered questions. So there is a significant amount of activism and improvement and setting up of systems needed. However, we must say that at least one step has taken place. I mean, in 2004, one step was taken. Now in 2023, another step has been taken. So I suppose that ultimately the way we did, the way we kind of abolished the MTP Act brick by every single situation, and we stepped 1 inch ahead. I think for living will a similar kind of thing probably might be needed, and ultimately we'll be able to achieve that sense of parity, that sense of privacy, that sense of rightfulness, that sense of dignity as far as dying is concerned. So this is what is just a humble beginning which I've done. I must say this particular fact that although Times of India made a news on the front page and all that kind of thing for me saying that I'm supposedly the first person, but the truth of the fact that Indian Society of Critical Medicine has done a huge amount of work. Advocate Arvind Datar, who coincidentally happens to be having the same surname, though not related to me, unfortunately. I would have loved if he was my relative. But Advocate Arvind Datar, Advocate Bhani Mehta, Advocate Dr. K.K. Raju, these were few of the important people who have realistically put in a lot of efforts to get this done. So I must acknowledge the fact that they have put in huge amount of efforts for this. And yeah, so that's it. I mean, that's exactly what I wanted to say.
Great. No, that's amazing journey. Would anybody talk
I
about
just
that?
wanted to mention that just before this judgment had come, the revised format, I happened to chance to see the living will formats in state of Illinois in the US, state of California also in the US, and one state in Australia. And I found that the procedure of living will was so simple there that it amazed me actually. And somehow we lost the opportunity of filing an intervention because our principals initially were keen to file. But when the constitutional bench was constituted to have a relook, then they felt that probably we are too late. And in the bargain, we lost this opportunity. And as Nikhil has rightly said, there's lots of scope of improvement, but yet at least we are much better off than what we were a couple of years ago. So that's all I just wanted to mention, that internationally there are very, very simplistic methods of registration of living wills and advanced directives. Thank you very much.
Sure. Is any other questions, or I can ask the first one?
Question, but Jamshid, go ahead.
No. So one, I mean, you mentioned, there are so many different sort of processes, procedures. I think as lawyers also, I had to call up Dr. Khatri and ask him, in fact, because there was a client, a particular hospital that was, this the whole issue about, as you, Nikhil, rightly said, that somebody wants, poor patient family wants to take them away, and Dama, and what will happen, and that's when I really sort of went into it. Uh, but I think, don't you think that something like this, which is so important in today's day and age, everybody finally understands the concept of the will. But the fact that you can simultaneously create this the living will, and also this issue about uh, what medical care at that point of time, uh, as a medical doctor, or as a habitual patient, probably you would know more, but a regular and a normal human being, citizen, I don't think he or she has any clue. I mean, because once you're in the hands of your physician or doctor, what uh, when you pull the plug out, what should you be on a ventilator or not? This, so in that sense, I mean, do you think a lot more sort of basic awareness, and importantly, medical information should be given?
Yeah, you want me to answer, respond?
Yes, sure, sure.
Okay. So basically, you are absolutely right. I mean, three small little points. First point, as you rightly said, that when you are at that kind of a scenario that you are now not looking at recovery, but you are looking at peaceful death, it is absolutely crucial, that person is kept as pain-free as possible. Okay. Now, that's the only thing actually, which is what is required actually at that point of time, because you are not expecting any recovery. Yeah? So the only thing that you have to kind of ensure that the person is as pain-free as possible. And that's where there is a huge amount of scope for palliative care. Now, in our country, I have found, and which is like far different and different than other countries, that in our country, people are not very keen on using drugs, especially keeping people pain-free from the palliative care perspective, because most of these drugs, I'll give you a simple example of morphine for that matter, because that's a word which kind of a lot of people have heard about. So there is a collateral damage, or a collateral side effect of drugs like morphine, which causes respiratory depression. Now, what happens is that when a drug is kind of being used, that in that kind of a scenario, that dose, okay, which will keep the person pain-free, we have to also accept the side effect of it, such as respiratory depression. But the doctors are very worried about this kind of a respiratory depression type of a thing, because they are always worried that, this is a dose that which is like very high dose and it will give rise to this kind of a side effect. And people will say that your medication caused side effect and that's why the death got hastened and things like that. Whereas internationally, the way to look at it, and that's where I would like to quote from the palliative care guidelines from the NHS UK. I mean, they are willing to give that dose of morphine even if person is at home. They will put the person on oxygen. They would just simply give that kind of a dose of morphine. And I mean, they would not look at it as somebody has given an injection to hasten the death or something. They will consider it as palliative care. They will consider it as the dignity that is being maintained. And by that, and for that, whatever was the pain relief that was required of the highest order, that was given. So that is how they look at it. And we generally tend to look at it in a little different manner. But I suppose especially when things like this advance directive is in the picture. So in my advance directive, okay, I have categorically added. Achha, by the way, I am sure that my advanced will copy or living will copy is just kind of a format, or maybe the step one. Maybe I'm sure that there can be so many more improvements that can be done while drafting it. But in my living will, I have said this categorically that I am instructing my physicians to give me the highest possible dose of drug, okay, to make me pain-free, without being fearful of the side effects of it. Okay, at least that is what I have written in my living will. Of course, every individual person has to decide what he wants to write or no. Of course, being a medical man, I understand it little more in more depth and more confidence I have. And that's why I've written this kind of a sentence. But you are absolutely right that we don't want somebody's plug to be pulled and let that person be left at the mercy of nature. Okay, till the time the person's life is taken. I mean, we want the person to be comfortable. We want the person to be dignified. We want the person to be pain-free. And that's why the whole palliative care will come into picture, I suppose, after this advanced will is concerned. And I suppose this advanced will also help, the thought process about organ donation, the thought process, even the thought process about making your own will, I mean, your property related will, because I'm sure a lot of you must have had that experience that people in our country, thoda COVID ke time mein, there was a little increment in people making their wills. But again, after that, generally, nobody wants to write their will also. I mean, they simple will also, living will to aage ka baat hai. But I suppose at least it has begun discussion amongst the, in the living room at least, that such and such somebody did. So should we do, can I do, what to do, how to do, and automatically the other also be a fallout of it. So that's a comment to Jamshed, what you said.
We'll follow the order. I think Ragini, Prashant Bhai, and then Samir. Please go ahead.
Yeah.
You're
Thanks,
on.
Sanjay. Dr. Nikhil, I just wanted to know, again, this is a hypothetical question, but then, what, if there is a living will, okay, and the proxy gets the living will, but just before the patient lapses in a coma or, some kind of whatever, if he says to the doctor that he does not wish to go ahead with the living will, then what happens? In fact,
Yeah, so these are practically genuine situations which can come into picture, because they have said that like your will, I mean, your last will be the final will. I mean, that's exactly what is supposed to be the story for will. The same story applies to living will. But as you rightly said, I mean, I have written a will today, living will today. And just 5 minutes before slipping into coma, I express my desire, that I want to revoke my living will. Okay, but that living will is already there, and while I say that, and I kind of just pass into coma. Okay, then the only person who has heard me, is the doctor and nobody else. Okay, there's nobody else. There is no document. So after I've passed into coma, there is no way, okay, to kind of confirm the change in the stance that has been kind of expressed by me. Yeah, so I suppose in such a situation, probably only doctor and the doctor is the only witness, so doctor only will have to say that, well, this is what was expressed to me, and that's why I will not honor this or something like that. Okay, so that's the only, because he is the only witness. I mean, the doctor remains the only witness. But then, I mean, theoretically, if you kind of give something to the doctor and doctor is not of a high moral standard and doctor keeps quiet, and then what will happen and all these things. So these are all genuine difficulties which one is likely to face. Okay, so that's why, that's the whole idea, that that's why the person who is making a living will must make a living will with full consciousness. And that's why when I have put my draft on the website, what I have done is, A, I have put it in PDF, and B, I have put a what do you call it as your background ka thing, what is that called as watermark, so that what happens is, because I am fearful of the fact that Josh mein aake people will just cut, copy, paste. Okay, and then they will say, oh, we never read this, but we just kind of signed, and I wanted to be the second person to file my living will and third person to file my living will, so I don't want that, so I want that the person reads through and he will have to type or write down. So when he's writing down, he will have to think that, do I agree with this or I don't agree with this? So that's the only safety measure which we can take at the moment of time. But I take your point. I mean, there can be a lot of lacuna in this.
Thank you,
Prashant.
Nikhil.
Thank you, Dr. Nikhil. Ajay. I just wanted to ask you, do you see the trend now with respect to the organ donation included in the will?
Yes.
And how far it is enforceable?
Yeah, it's very much enforceable.
No, but see, now what has happened is that right now people are, see, there are a lot of NGOs are there across India where they are pledging on asking people that आप अपना organ donate करिए, donate card बनवाते हैं, ये सब चीजें करते हैं. There is no central registry or anything like that, but so nobody knows. So that whole exercise is being done for a goodwill gestures. People are doing it and so on and so forth. And in that case, even if the person comes out with this card, then also the law says, or what I've read on the internet and talking to the couple of other lawyers, that if the family member says that, well, we do not wish to donate it, nothing can be done. Now the question is coming back to that, if you are making a living will in India and you are including in that one, whether it is a registered or a non-registered will, and say, for example, without going into the technicalities, that it has remained as a good will, then can the family members challenge it or cannot challenge it? So is it a way for me to fulfill my wish? So my near and dears may not change my wish of not donating my organ to the people. What is happening?
Absolutely right. I mean, see, basically, I suppose, well, this whole living will thing comes into picture. I suppose the premises of living will is that I am giving proxy to somebody who is my confidant and who is a near and dear one, and he will respect my wishes.
Right.
Okay. The only thing, that up till now I was expressing it verbally, and that's why there was a sense of unsurety or lack of clarity. But now, because it is in the writing, the person who is the proxy holder also gets a lot of strength because of the fact that it is in writing. But the basic premises is that I am giving it to a person who is holding my proxy. So I feel that he is of confidence. I feel that he will honor my feelings and my commitment, and he will not go back on that commitment because of the bond of love that I share with that particular person. But if that bond is changed or breached, then in that scenario, what will happen is a big question mark, and that will hold true as far as living will is concerned, that will hold true as far as organ donation is concerned, that will hold true for all of these kinds of things. So rather than having a card, if there is a living will, which is like with a gentleman or the man has kind of taken efforts to take two witnesses and go to the notary and notarize and send to a custodian. I mean, it has got a lot of force behind the whole action, that this is exactly what this man wanted to do. And that's why if he has written, that my organs have to be donated, then the relative should feel that urge, and that sense of compulsion, that out of the love what they had for that particular gentleman, they should abide by the wishes expressed by this particular dying person in the living will. And I think that's only what is the force. But I completely accept the fact that suppose somebody just simply hides the living will, just does not come up only with the living will, or just does not talk only about the living will, then how are you going to enforce it? So that's a question which I think is unanswered. And
that remains the situation to situation, case by case basis. Means I have seen in foreign countries, particularly in Canada and in America, you can go to a stationery store and you can buy two types of forms, which I have seen. One is if you are renting a premises, you can have a rental agreement, fill up your informations, and your rental agreement is done. And the second one I have seen is with the will as well.
Yes.
That you can fill up the informations, then they will give you that whatever you want to write extra, you put it in an annexures and your will is done. If you want to get it registered, you can get it registered. It's as simple as that. So how far the people are serious about registering the will here in India?
I think all in all, I mean, lawyers will be able to guide more on this. I mean, I don't think I'm the right person, but at least as a doctor, what I find is all in all, not many people are writing their wills. And I suppose those who are writing their wills are registering the wills.
No, I mean, yeah, I agree too. Okay, because that's the way the whole area of practice has started in India, where about the estate planning, because this is, we are talking about the medical part of it and how should I die or not and what happens to my organs and the intellectual properties and so on and so forth. But also like a wealthy family has another issue is about the inheritance as well. So that's like a whole scenario goes in a full circle with the different properties and aspects of the thing. Anyway, thank you. I've taken a lot of time. I appreciate it. Samir bhai.
Thank you, Dr. Datar, for that very interesting, discussion and information about the Act. So I would just take the last part of your observation and just make a suggestion first. Jamshed, I mean, to be considered that why don't ILA as a group works on the critical analysis of this Act and to suggest best possible solutions to the government and the authority to make it, foolproof kind of thing. I know any law cannot be foolproof, but what observations Dr. Datar made about even after the judgment, there are still so many lacunas, loopholes, big loopholes. Why don't we as a group take up this as a research project and, give our observations, our solutions to the government? That's one suggestion.
Sure. I think that's absolutely well taken, and I think that will be a big takeaway from today. Yes, Vivek.
Yeah. And the second aspect, Dr. Dada, you said that in our country after the judgment, the active euthanasia is not allowed, but passive is what this act talks about and what you just mentioned about living will and all. One question which arises in my mind is that, don't you think that passive euthanasia is sort of also, prolonging the death as such? And if you see from the living will perspective, see the person who's there, he or she may not be so aware about the, the guidelines or the situations where you can say that, okay, this is a time I can just let it go. So ultimately, it all ends up in the hands of the treating doctor, as you mentioned, 2 levels of committees being made, and then ultimately information being given to JMFC. So there are a lot of things which coming up, but ultimately, isn't this passive is sort of prolonging the death?
No, actually, passive is not prolonging the death. Full-fledged, full-throttle, doing full-throttle treatment is prolonging the death. Passive euthanasia is actually withdrawal or withholding of treatment. So basically what you are doing is that you are just basically ensuring basic nursing care, okay, basic cleanliness, basic nursing care, keeping the person pain-free, and just kind of supporting the person to kind of have his last few days or whatever days or minutes or hours, to be as peaceful as possible. That's what is passive euthanasia. So there is no question of prolonging the death. So let me give a simple example. Today there is somebody who is like at a situation where he's like in agony and in pain, Okay, and I mean, I recently had one such kind of an example. You know, a lady who was almost 98 years old. Okay, and she was just not kind of passing away actually, and she was in that kind of a scenario for about 8 days in a doctor's house itself. Okay, I mean, she was shouting with pain. She was saying that why the God is not taking me away. Okay, but she took good 8 to 9 days in severe agony and pain. Okay, so passive euthanasia, so full throttle treatment will be to take the patient, get the patient admitted into ICU and start whatever it is. And then, you know, kidneys have failed to do dialysis, lungs have failed to put on ventilator, heart has failed to, you start giving medicine so that heart starts working. So all that kind of thing is full throttle treatment. And doing nothing, of course, that's a choice that every individual has. And passive euthanasia is probably you would put this person on an oxygen cylinder, give a good nursing care, probably something which they would do in hospice, and give good amount of painkiller so that the person is pain-free for those 8 or 9 days.
Okay. Taken, understood.
Pain relief is a very crucial part of passive euthanasia.
Which of course also remains part of the regular treatment as well.
Yes, but in regular treatment, what happens is that the whole aim and objective, you know, is to kind of, you know, look at possibilities of person reversing that.
Survival.
Well, you know, you will kind of, you know, not want to go to that level of pain relief treatments and all that kind of thing, because you'll always keep on thinking about the side effects.
Correct. One thing what we were discussing last about this organ donation part, the question which was raised by Prashant Bhai. Don't you think that if the part of the organ donation, because what we just saw about the issues that could happen if it is made, and you know, and let's say a person tries to revoke this living will. Don't you think that if this organ donation part, which anyway is going to happen after the death, it's not going to happen during the lifetime. So if this organ donation part is left to the regular will, I think the whole problem would be solved.
I don't think that there's a problem really, because what happens is, see, I mean,
problem in the sense that what we were discussing earlier, that this issues could come up.
Yeah,
for
again,
that matter.
let me, I mean, of course, I stand corrected because practicing lawyers are better off than me. But if I primarily understand, okay, typical will is supposed to talk about the property and all that kind of thing, inheritance, property, so on and so forth. Now, when somebody has died, okay, organ donation is supposed to happen in few hours post-death.
Correct.
Now, when somebody has died, now imagine a situation that I have written a will. Theoretically, my will should be read after my death, which means after everything is done, after all formalities are done, everything is done, then family is supposed to get together, lawyer is supposed to come, the executor is supposed to come, he is supposed to open, you know, and then read out. Which might be maybe 13 days later, which might be 8 days later, which might be 4 days later, which might be 5 days later. Now, if at all I have written a will and I have, let's say, deposited with you, Samir Bhai, for that matter, and my relatives are not aware. Okay, by the time my relative inform you, whereby you are aware of the fact that I have written XYZ in my will because you are the executor, it might be 24 hours, it might be 48 hours gone past, by which time I will be cremated.
Correct.
So it means that if I am writing a will, then it means that at least certain part of my will, okay, which theoretically should not be told or not necessarily required to be told to anybody. It should be like a written document which only the executor should know about it later on. I mean, the beneficiaries, and usually the beneficiaries will be those people with whom you are likely to stay. So you want the beneficiaries to know later on, you know, not during the lifetime what they have, you know, what they are supposed to inherit, all that kind of thing. So then why should I tell some part of my will now only, okay, Baba, if I die, then you have to do this organ donation and that organ donation. Okay, I mean, then I can write it in the living will itself, no?
Correct, you are right that way, but see, today what is happening, first, people are really not aware anything about living will. They don't have any knowledge about it. So I think that is another part which we should be taking up as a organization to promote this. And what is happening, you are right, and that's the practical situation right now, that today people are making all these aspects, including organ donation, in the will itself.
Absolutely.
And normally what happens, that person at least tells somebody very close in the family that this is what, may not be the whole content, but at least they always make this wish, tell the wish that this is what they want to do. And therefore the organ donations are happening anyway.
Absolutely.
I mean, I give you example of my own father-in-law. When he expired way back, we donated his eyes, and that's what his last wish was. Though he died very sudden with a very massive cardiac arrest, there was no one with him at that point of time. But sometime, some discussion took place, and he had expressed this. So likewise, this is the practical situation in all our Indian homes across. But yes, you are right. We need to make this more, promote the awareness about this, the benefits of this will across. And also, as lawyers, we should be now advising the clients on this aspect of both the living will and the regular will, coupled with, of course, the organ donation part and the estate planning.
Absolutely. Absolutely.
Thank you so much, sir. Thank you. Thank you so much.
Yeah, Vivek, please go ahead.
Hello, Dr. Datar.
Yes.
Thank you for this wonderful session. I just have a few doubts. This it might sound idiotic, but just correct me wrong. With regard to the serious disorders that a person might have, right? Is there a specific cause which, with regard to changing the advanced directives? Because, like, if we look how things are in US with regard to the living will, apart from the general living will and the advanced directives, we also have a specific provision, although not mandatory, but we also have a provision for the orders of life-sustaining orders, right? For serious disorders or sustainable disorders, life-sustaining disorders, right? So in that case, like, how is it different with regard to the advanced directives, or is there a specific route that changes with regard to a person who is generally into an illness versus a person who is seriously into a disease, which for sure we know that the conclusion of that might not be a very positive one. And so furthermore, just one more small question. Like, I definitely agree to what Samir sir said and Prashant sir said with regard to the organ donation. But apart from the ones who are already dead, apart from the organ donations which happen to from the dead people, we also have certain instances where there are living people who are doing it, right? Maybe for their relatives or the closed ones, right? But with regard to it, there is a huge requirement of compliances with regard to residency and domicile, right? And it has been a problem for some time continuing. So do we see anything different with regard to a living will concept rather than a general will, or rather a general organ transplant with regard to within the relatives or difference, right? Because there also comes in an idea of citizenry for that matter. So yeah.
Yeah, I mean, see, we are primarily quite early in this whole journey altogether. I mean, we don't have at least legally required multiple forms and specific instructions here and specific instructions there and all that kind of thing. Currently, we just simply have one single living will. We are struggling at the living will itself in the first place. So going in terms of further specifying things that for this is what will you do, and that this is what will you do, and all that, okay, seems a little postgraduate, I may say so. Okay, because we are at undergraduate level, at least as far as jurisprudence is concerned in India. But of course, I mean, the order has also said, and it is a fact, that more and more the person is aware about what does he realistically want from himself, from his own body, and from the medical fraternity or the healthcare organizations. More and more he's aware of, the better it will be. And I suppose that the ideologies may also change. I mean, today, if I have done my living will, I'm sure maybe 10 years later, probably I will like to revoke this living will and probably file another living will. Because the things may change by that time. Okay, but I will have to be aware of the fact that, okay, things are going to change. Maybe some diseases which today we are thinking that they are terminal in nature, probably they may not stay terminal in nature. So maybe my next living will after 10 years might be more evolved than what it is today. Okay, so we will have to keep pace, with the advancement of science, and that's exactly what happens with health law. That's why I always say this, and I always quote this at every time whenever I speak, that basically health and law, both are made by humans, made for humans, and hence because humans are imperfect, they are also supposed to be imperfect. Number one. But interesting part is that medicine is always criticized for it being too swift and fast in terms of change, and law is usually criticized for it being too slow to change. So keeping pace between law and health, okay, is a big challenge. And the same probably would happen with law and technology. Okay. But this is what is the thing that that will have to be, people will have to keep on bridging, and that's exactly what happened with MTP Act. I mean, something which was path breaking in 1971, when even sonography machine was not available. I mean, today looks so outdated. Okay, in 2023, after 51 years or 50 years, that whatever are the provisions, they look totally outdated. And that's why the law had to keep up pace with the advances in medicine, and this is one of the area where it will have to happen, that the pace will have to be kept with the advances that are happening. Now, second comment that I will like to make is that what I find, okay, that we have done this piecemeal type of work altogether. I mean, we have a separate, because see, there is a need for organ donation. So that's why we have our Organ Transplant Act. There is a fear in the mind of misuse, and that's why the rules under that Organ Transplant Act and the way they are kind of, bureaucracy uses them in such a way, okay, so that there is a sense of jitteriness amongst those hospitals who are doing organ transplant in these kinds of scenarios. There is a need for living will, and there will be a sense of jitteriness about misuse. So basically what I mean to say is the general law, organ transplant, living will, if you keep all these things together in one basket, you will find that there are so many confusing points over one another, that somebody needs to. So I absolutely agree with what Samir bhai said, that we at ILA probably should do this kind of a work. And I would just add to it that we should not do only some kind of work about living will, but we should also look at, general law about death, general law about death in general, about your organ transplant, about living will, all together, and kind of suggest that, well, these are the problems that we will be facing. Because it is typically otherwise a knee-jerk reaction. You look at a particular situation, you create a law for that situation. Then suddenly something happens, there is some misuse done, you suddenly change your rules under the act, you suddenly kind of take 5 steps behind. So it becomes like a share market, keeps on going up and down, up and down, up and down. I mean, that's not what is ideal.
No. So just to bring you up to book, in fact, Prashant Ajmera and others, public interest litigation was filed, and thereafter a lot of work has happened very recently on the aspect of domicile and age of organ sort of transplant and things like that. So it's there's a you know a small little group that has been created, and a lot of information, and it's very interesting. So that's one area that has again sort of uh, emanated through ILA, and I think you know uh, we've achieved remarkable success in such a small period of time. So all that information, I mean, do get in touch with Prashant Bhai, and he'll
Yeah, surely. I like to be
oh,
very keenly
sure,
interested and participating also. Interested in
definitely.
participating.
So yeah, so I think you know, thank you very much. Thank you for giving us direction, and I think that is important. The takeaways, I think we should, as ILA, take this ahead and look at it on a large sort of a and on quite often sort of understand where sort of the best practices that are available. And I'll never forget, if you remember, even in the MTB matter, uh, you know we had pretty much given up right in our first discussion that India is a hopeless situation. So, and I said, let's look at the law in other countries, and we were happy that we found UK law, and we actually took that up and argued it in court, and ultimately now it's of course gone way beyond. So yes, I think we should take this up, as and whoever from all our members, we put it up on the main group as well, and I think it's a great step in the right direction.
And one more small little request that I wanted to make. I mean, I happen to be honorary professor of law at the National Law University, Maharashtra National Law University, where I teach law. So, I have a lot of young blood which is available, students interested, etc. Some little stipend here and there, and they are willing to work. They also get that sense of credibility to their CV in terms of applying and all that. So if there are any such kind of opportunities, I mean, I'll be very happy to coordinate between the students of MNLU and you people, whereby it's of a mutual benefit to both the sides, and some good work can be created out of it.
Yeah.
No.
Recently,
you are right. Sorry.
yes.
Prashant.
Go ahead, Samir bhai. Go ahead, please. Go ahead.
No, I'm just adding to what Dr. Datar said. I think that's the way it should be, and that's how these research work and things goes up. So we'll definitely will need those kind of volunteers to support us, and of course it will be helpful for them as well. As you rightly pointed out, for their own enhancing their own intellect and knowledge going forward. So yes, we'll definitely work into that. Take help of them as volunteers, and then of course the ILA members are anyway there, and you being the expert on that, and we can then take it forward from there.
Yeah, surely it will be an honor, and I'll be very happy to do it, sir.
I think Mr. Tamiz Kumaran is raising and
good evening. Good evening, all of you. It has been quite enlightening to hear from the doctor on a different perspective. And as a practical issue, all the three wills have to be had separately. They should not be integrated into a single will. That is a very practical move that we will have to take. Though there is also a possibility of donating the entire body post-demise, immediately after demise. So some organs are
Have we
I
lost?
think we've lost him.
Can't hear.
I think Ragini madam has said that she has some question or something, or
Doctor, I already asked you. I don't have any
yeah,
question,
okay.
but I will ask.
Okay.
Okay.
Jamshed, just one last suggestion, if you permit me to do that. I think this has been a very, very interesting discussion what we had. And I would suggest that let's have a follow-up to this, because I'm sure there would be many, questions, thought processes, which, and we need to continue this. Then only, it will serve the purpose of it. Just one-time discussion is not going to help us out. So, and if we are actually agreed to, in principle, to work on a research aspect, I think there be a follow-up meetup on this, so that now whosoever is there, they are well prepared. They have their own thought process. They can also read up and then come out with further discussions point.
Sure. I think that's can very happily be done. If Mr. Kumar.
Yeah, like recently, as you said, the sharing of the knowledge. I was just invited at the law college in Ahmedabad to come and talk about the immigration. That's what I do it. I said, look, this time I don't want to come and talk about immigrations. I will give you a different topic. And my topic was the interpretation and misinterpretation of domicile in India.
Oh.
Because the domicile is only for in India as the lawyer, what we understand. And the way in which the state governments and bureaucrat understands is the they should use the word like a residency and resident rather than domicile, but it continues. So when I give that distinction, they find it very interesting, and they say that, okay, now this is the reality, we see it in the life. And we talked about the judgments or the case which Jamshedji mentioned about the PIL and the repetition in Gujarat. So yes, it's always the sharing of the knowledge is always good for the faculty and good for the audience, students as well.
True.
Mr. Kumaran, are you able to ask a question or?
I think it's 9:20. Probably we want to call it.
I hope my point was fully expressed. Beyond that, I think I rest my things.
Okay.
The point is that all the three categories of wills have, as a practical measure, have to be separately drafted and registered, or whatever means that we adopt.
Okay. So thank you very, very much to especially Dr. Datar, Dr. Khatri, and all the rest who have even asked questions. I think I agree with Samir Bhai that this is, let this be treated as an introduction to the subject. And I think, the law is and the learning is continuous. And I think we are all students, and let's take it ahead. We'll put it up on our a regular group, and thankfully this is being recorded, so this will also form a part of that, and let's take this up, and we'll Nikhil will definitely coordinate with you and see how best we can uh, take it ahead with the students of not only this the National Law College, but even other colleges who might be interested. So let's take it ahead. But thank you very much, and this was extremely useful to all of us. Thank you.
Yeah, thank you for adding me to the group. This was a very elite group that I am added to, and that too of lawyers. Coincidentally, Jamshed has called me Dr. Datar from the evening. He normally calls me Attorney General, Attorney Bar at Law, and law advocate sir, and all those kinds of things. So
finally, it has come.
He's reinstated me at my original position of being a doctor.
Correct.
Thank you very much, and good night to all of you.
Thank you. Thank you so much. All.
Thank you. Bye.
Good night.
Okay, everyone. It was nice meeting you, Dr.
Good night. Good night. Very enlightening.